Okay, so we left off in part 2 of this family court recap with the order setting a hearing September 19th, 2022. And they said the time reserved for the hearing was 30 minutes. So on August 25th, 2022, exactly 3 years ago, Brian submitted this financial affidavit, which is basically just a fill in the blank form that he submitted. That his occupation as a software developer. He's 47 years old at the time he filled this out. He marked unemployed, but that he is looking to find a job that pays between 60 and 80K a year. So he didn't fill out an employer because he marked unemployed. This is the income for the tax year 2021. He put that his income was 0, and Sarah's, he didn't put anything. So the total of all lines is going to be 0. He didn't pay any taxes. He did file head of household and claimed one dependent. So my takeaway from that is he did file head of household as his filing status for 2021. And if he claimed unemployment from the IRS or claimed being unemployed to the IRS, that's really all there is to it. You're not going to find if he's doing, work, side work, cash, payments only. There's nothing anyone can do to prove that, especially when you have very limited resources and abilities to research it. You would basically have to hire some kind of a private investigator to dig into someone's finances. And if the IRS hasn't found it, it's not very findable. That's just my opinion. But if he did file taxes in 2021 and claim that he didn't make any money but is the head of the household, then what do you think the court's going to be able to find? Okay, now he is listing all the expenses to live in the home: monthly mortgage, electricity, water, garbage and sewer, telephone, pool maintenance, pest control, miscellaneous, food, meals, and television service. So that all totaled to about $3,300. Car expenses, $154. Children expenses per month, $155. So at this point, he must not have health insurance. You can, if you're unemployed, apply in the state of Florida for your children to still have health insurance through the state. I'm just speculating that that's a possibility, but it doesn't have any premiums he has to pay. And then pet expenses, for the food and etc. Creditors, it says he's currently not making any payments to the 3 creditors he has. So total monthly expenses, $36.68 back in 2022, August 2022. This is what he claimed his expenses to be. Whether or not he is employed, these are the expenses required for him to run a household to care for the child that they are both responsible for. So Sarah not contributing and not having any parenting time sharing for that would be responsible to help support the livelihood of the child. And we will look forward to seeing a court order on that in the coming weeks. He does show that he has a checking account in the negative. Money lent to Sarah Boone right here. Whoops. Sorry about that. Money lent to Sarah Boone, $20,000 estimated. Respondent owes petitioner in excess of $20,000. Now, how he decided that amount, I don't know. Presumably, he would have receipts or evidence if he's submitting it into court. Real estate, current fair market value in 2022 would have been about $450,000. His 2011 automobile would have been an estimated $10,000. He had a 401k plan with a balance of around $41,000. If you sold all the furniture in your home, it would be a stretch to get $5,000 as it is now used furniture, but he's estimating his furniture at $5,000. So the total assets he's saying he has, $528,000. Currently owes $238,000 on the mortgage of the home. So if he were to sell it, he could make some money. But as we saw in the settlement agreement, he gave Sarah a lump sum of her interest in the equity of the home in the 2018 settlement. So as long as he can prove that he paid that amount that was ordered, if he sold the home, he doesn't owe her any money out of the sale of that home. So that could be, this is speculation as well, that could be that he sold the home and he, was able to live below his means on some of that money from the sale of the home. He does list balances on 3 credit cards, totaling about $15,000. So his total debt at that time was $250,000, roughly. So total assets minus his total liabilities leaves $274,000 of net worth. There are no contingent assets or liabilities because that was already ruled in the final divorce court order of 2018 that we looked at. No other debts can be incurred that the other person is liable for, and they don't have claim to either of each other's assets. And then they mark that a child support guidelines worksheet is or will be filed in the case. This is required. And we looked at one in part 1 or 2, I believe it was part 1, where they filled out the initial child support worksheet, and that's how they determine the amount of contribution from each parent. Now, Sarah's, of course, this is speculation, I'm not a professional, her estimated contribution is going to be 0 or close to 0. So that leaves Brian with supporting the child completely. So we'll have to see when they file the updated child support worksheet what they expect to be contributed from Brian, what they expect to be contributed from Sarah, and how they would calculate child support owed possibly from Sarah. And it just says that everything in this document is true. And here is the certificate of service that they mailed to Sarah Boone when she was at the Orange County Jail. Now, how many times have we seen her request documents from other people, such as Brian's financial information, but they mailed her a copy at the Orange County Jail? In 2022, this was dated August 25th, 2022, which means it probably would have got there around Labor Day or thereafter. So within a week, it would have gotten there. And she would have had every single line by line item that Brian filled out on this paper. She may or may not agree with it, but she had every single one of these numbers. What he had in his 401k, everything. She had this. It was mailed to her. It was provided to her. How many times has she written that she needed this information, that he's hiding information, blah, 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 blah. This is what he provided the court. Now, the court can request bank statements and things to support what you put on the sheet, but this is what was provided and filled out at the advice of his attorney. So, probably reviewed by his attorney before filing with the court. So, since there is a certificate of service that it was mailed to Sarah Boone in the Orange County Jail, she can't claim that even if she lost this item, that she did not receive it. Okay. It is your responsibility to keep up with your copies. It is not anyone else's responsibility to provide you endless paper copies that they have already provided to you. I'm assuming, I'm not a lawyer, but I would assume that if you have documentation that you sent something, that you've provided it, maybe one second time if they claim they haven't gotten it would be a good faith effort. But at that point, I don't think that you're responsible for providing it any further. Okay, so we looked at the order setting the hearing in part 2 of the video. We just reviewed Brian's financial affidavit he filed. The judge also filed an order directing Orange County Corrections to transport Sarah to the courthouse. I'm not going to pull that up. It's just saying to transport her to the courthouse at this time and date for the hearing. Now we have 2 letters written kind of back to back. They're dated 2 months apart roughly, but they were filed a couple weeks apart. So I don't know how long it took her to mail them out or what. She had another letter dated the same day that was filed on July 28th. So that was the last letter we read in part 2. Now let's take a look at these 2 letters from Sarah, and then we'll move into the hearing they had with Judge Michael Dean and what was presented then. All right, so buckle up. This is her letter written on July 17th, 2022 and filed 8/29/2022. There's no envelope at the bottom. I'm not sure if she mailed it. I'm not sure what took so long for it to get filed, but here we go. Judge Dean, so she's addressing this directly to the judge. After coming back from an outside medical appointment for my cancer and surgery, I really wanted to call my son to hear his voice and brighten my long, arduous day. In doing so, he was checking the mail telling me I had a letter from you and wanted to be helpful and read for me. Now, you should have stopped him right there and said, give that mail to your dad, because you are not supposed to open mail that is not addressed to you. So you're encouraging him to do something he should not. He should know what he should not do. Second, you should not be putting your child in the middle of the legal mitigation or mediation, whatever you want to call it, between you and his father. As you point out all the time, okay, you took the same parenting class. You know you're not supposed to do that. Also, he's only between 11 and 12 because this was written in July 2022. So this is not appropriate already. He wanted to be helpful and read for me. No, you asked him to open it and read it for you. Stop lying to the judge. The document was an order to dispense mediation stating, 1, the order was granted by you. 2, parties can move forward, meaning former husband and his attorney, as I'm just told what to do and have no representation. The case is set for trial when? And 3, the court remains over jurisdiction in this instant case. What does that mean? Now, they have given certificate of service that all of this has been mailed to her. And we will look at that. She might have found out about this from a phone call before she got the mail, but she still is receiving certificate of service of the court hearings. This she wrote on July 17th. The court hearing wasn't set until 9/19, so she may not have had the notification of it yet, but we'll look at the dates on those. What does that mean? So the judge is not allowed to give you legal advice. 11-year-old was finished reading. His response was, I'm sorry. I don't know what Dad's trying to do now. I myself am trying to figure out what new underhanded terror he's attempting, so I decided to call him directly and ask. One, why was this sent to him and not me, the other party? Probably because he is also a party in the case and they both got receipt. Just like everything else, they send a certificate of service to the other party and file it with the court, so he probably got a copy of it. What else am I not receiving or being informed about regarding this matter? Two, why did he not communicate anything to me or with me during any of the multitudinous phone calls we've had since this order was granted or prior to even being generated? So this could be avoided. Well, probably because he's not supposed to talk to you directly about legal matters because he has to go through his attorney, and so do you. And also because that would be a giant migraine to talk to you about it. Nothing would get accomplished. So I don't know why you said it could be avoided. It would just be prolonged. I call almost every day to speak to my son, then call former husband during the day while my son is at school to try and attempt having reasonable conversations/discussions. Oh, really? About personal matters such as this. Okay, but do you need to talk about that every day? I wouldn't think so. I am trying to alleviate any additional difficulty. No, you are definitely not doing that. I am trying to alleviate any additional difficulties and am constantly coming up with solutions in everything to work with former husband to complete this process in a positive, fair, and accurate manner. So solutions have to work for both people, not just you. And just because you're not getting your way doesn't mean it's not fair and just. How can this be done now the mediation has been, quote unquote, dispensed? Well, in a court of law, that's how it can be done. Like they notified you about the hearing. Both parties could have figured something out instead of just canceling completely. Well, they tried, but you wouldn't give them any dates. And you said you had no idea when you could possibly give them any dates. And you asked for a bunch of legal advice from Brian's attorney. So they said, this isn't working. Can we just dispense with this? And the judge agreed with them. Now you're writing the judge? Apparently. Former husband could have explained his intentions to help understand my circumstances better in being unable to choose a date for mediation. See, right here, you just told the judge you are unable to choose a date for mediation. So how can it move forward to mediation if you were unable to choose? How can this be done now the mediation has been dispensed? One sentence later, you are unable to choose a date for mediation. You answer your own questions. Okay. Sorry, mid-sentence. To help understand my circumstances better and being unable to choose a date for mediation 4 months in advance. Girl, you don't got nothing going on. On top of my cancer, on top of my trial, I simply asked for help from former husband and his attorney. Is attorney in quote unquote, or is that just, I don't think it is. And yourself, your honor, to provide information. No, legal advice. That's what you want, legal advice and copies. So I could choose even if the date had to be changed. But you didn't choose. You said you had questions and they can't give you legal advice. So they said, okay, she's not being cooperative. No mediation. I, the other party, was bypassed. No, you were written and ignored completely with no explanation from anyone. That is true. They did ignore you, except for mailing you the notification of hearing, because they can't give you an explanation because they're not allowed to represent you and the other party. And the judge is not allowed to give you legal advice. I'm not a lawyer, but this is what I've heard. I wasn't even able to respond in a more timely manner because I never received the order or knew was granted until my son happened to check the mail that day and read it to me. This mediation is all I have. Oh, girl. Everything is always all I have. To be rightfully heard and utilize my rights as a mother and human being, to be seen in a clearer light, not as the one-sided, ugly, unfair, slanderous everything said by former husband. I attempted to be professional and correspond with everyone. I explained my situation and simply asked for some important documents to be better prepared, as this would probably be my only opportunity to make myself count in all of this. Yes, but they can't give you those documents because that would be providing you with paid legal assistance that you are not paying for. Okay, I asked how to set up a video and asked if face-to-face was an option. My requests and questions were all in an attempt to choose a date and schedule this much needed, very important mediation. So the video question would have been best directed towards the jail. I don't think the court can control that. I mean, they do have one end of the video, of course, being able to receive it, but I don't think that's the issue. I included you also, Judge Dean, after being instructed by former husband's attorney to correspond to him so you would know my attempt, request, and willingness to cooperate, as well as my eagerness to complete. I simply asked for paperwork to review as I do not have any and am being accused by former husband of being difficult and uncooperative by not signing documents I've never seen or knew existed until being served with a summons notifying me of his means to take all I have left other than the marrow from my bones. Again, the dramatics. What is he taking from you? The alimony that he's also giving you. So take all I have left that he also gave you in the first place. It's just so dramatic. Please understand, I never said no or that I was not going to schedule. I want to be at my best possible with all the information for my review beforehand, as would former husband be and his attorney, but not myself unless I requested. Why am I being penalized for wanting to be prepared? Well, you're not. You're being penalized because you haven't hired an attorney to do these for you, and no one's going to do it for free. Why was no explanation or reason given or discussed for canceling the mediation? Why was no attempt made to make sure I, the other party, and the other parent was included along with everyone else to have the same understanding of what was happening? Why was my copy of this order not sent to me at my current location, instead to former husband who already knew since he was the one who generated the plan? How would I have known any of this if not found and read by my son? Completely unfair and wrong. I am being penalized for doing everything I am supposed to be doing. No. And for my attempts to show my heartfelt desire and determination to be a part of this, to rightfully be the other party. If I have to go through this too, on top of everything else, I will and am. It should not be held against me to correspond, make my basic requests, and ask questions to choose the correct armor of choice for this mediation and ongoing battle. Oh, that's not a good choice of words to use with the judge. So I can confidently explain myself and fight for my rights and to be the mother I am and will always be. I ask for nothing out of the ordinary. Any caring, competent mother, human being would not themselves ask for in a situation as mine. So you say. Also, in the letter to me from former husband's attorney providing me mediation dates to choose from, 7/5/22, have you seen? It specifically states, please respond to this correspondence within 20 days of receipt with your preferred date and attendance method. Otherwise, we will unilaterally schedule the conference and send you the details. I did, and I did with my request to help give me a better understanding. So why wasn't this unilaterally scheduled as stated? It was canceled. Would it have been better on my part to have just not corresponded at all so this mediation could have been unilaterally scheduled? I feel if I had not made my willing and eager attempt to abide by everyone's rules and played the part of the terrible lowlife inmate former husband and what seems to be by everyone else wants me to be, no, that's just what you are. I would be preparing, reviewing, and working around this unilaterally scheduled mediation. I do not understand, and no one has made any attempt to help me to. Well, you never understand anything, even when it's explained in a loop multiple times. You still just claim you don't understand. Honorable Dean, please understand this mediation is everything and can help ease the ongoing pain of whatever former husband's daily terror is he chooses to inflict. See, this is so bad for her to write to the judge because she's showing like how she is victimizing herself, painting herself as poor, pitiful, put in this position of no fault of her own, that she's just trapped here, that she can't get out, that there's nothing she can do, that it's just a total injustice to her. He's not going to get involved in your criminal trial. He's trying to be a neutral party, and you're saying all these negative things about the other person. Now, is Brian writing and his attorney writing saying what a horrible person you are, what you did? I mean, they very basically said she's incarcerated. This is why. These are her charges. That's it. You are throwing darts and doing it in writing. It's just not smart. Okay. Daily terror he chooses to inflict makes me beg pitifully for pictures which I still have not received. No one made you beg. No one made you do that. You chose to do that. Has me call every week to ask for commissary funds so I can purchase necessities and sugar for my glucose concerns, then says no, refuses the occasional hot meal on a Sunday. I was made to cry over a cheeseburger when explaining to him the amount of weight I am continuously losing weekly due to being sick, and thought this would help me gain by eating. I was still told no, because he is not obligated to buy you a cheeseburger now or any other day and never was obligated to. And you are not losing weight. Okay, we all saw you. You have gained weight. You are not no 105 pounds anymore. I'm not saying that's a good or bad thing. I'm just saying you're not losing weight. And if you are sick, the prison has, I've never experienced this personally, but there is medication and a nurse, and you can request to see them. I'm not saying that she doesn't have to pay for those things. I don't know. But if you actually are diabetic and have a glucose issue, I would think that there would be prescriptions that they would be obligated to give you to help manage it, not just sugar packet. Here's a sugar packet since you're diabetic. I don't think so. That's not logical to me, but that's just me speculating. I could be wrong. I'm not afraid to be wrong. I can look in the mirror and say, well, I was wrong about that, and move on with my day. All right, back to the cheeseburger. As far as I am aware, the dissolution of marriage agreement regarding alimony, which I did sign, is still and has been in effect, meaning I have funds available to purchase the aforementioned and had been doing previously with no problem, conflict, or difficulty. Everything was non-confrontational and smooth running until former husband implemented or trying to these inaccurate, unnecessary, quote-unquote modifications. The quote-unquote relief he is seeking could have been avoided, but he doesn't want to avoid it until he decided to involve our son. How? You're the one that keeps asking to involve his son. And my maternal rights. Again, one obscure... Ma'am, please stop describing it as this. One obscure, unfortunate incident does not or will ever define who I am, and it makes no difference where I am for former husband to think I am unable to make meaningful, moralistic decisions involving our son. Yes, it does. Like, you can keep reiterating that. It doesn't make it true. It is not an obscure, unfortunate incident. It happened and it is defining you. That is how everyone in the world first comes to know about you who didn't already know you beforehand. And we were all completely baffled. Regardless of my circumstances, this mediation will allow a just and fair opportunity for both parties to be equally heard. The mediation has already been dispensed, so I don't know why it's already been ruled on. I can make everyone aware I am someone and worthy, most of all, for and to my son. Please, Your Honor, please allow the mediation to be scheduled. Please take into consideration everything I have graciously said. You did not say anything graciously. And explained everything I still want to say and have a right to. Please, or provide another suggestion with some kind of facilitator, that's called mediation, to give a neutral opinion and assistance to both parties to work together. So that's the process: mediation or court trial or hearing. The judge is the neutral facilitator or the mediator. Those are the options. Two parties, two sides, two voices. How else can I be heard? Well, this letter, seen or accounted for. I too have defining points for discussion, and my understanding was this was part of or the reason for the mediation to aid in a fair, reasonable outcome for both parties. For compromises to be made, not controlling demands. Specific details need to be discussed regarding all of the agreements, as some I have not even seen. The supplemental petition for modification of final judgment and joint stipulation for modification, the most recent. What is their pre-modifications for all? This being why I requested these documents. And they cannot provide you with these documents as you are not paying for the attorney services. So requesting them from the opposing party's attorney is the wrong channel. You cannot get it that way. And they are sending a certificate of service to you through the mail. So maybe you just haven't gotten it before your husband got his and your son opened it. That doesn't mean you're not going to. In summary, oh, thank God. So because I have nothing and no one, as usual, former husband having an attorney that he's paying for, multiple monetary resources that he earned, a familial support, okay, why shouldn't he have that system, also with unlimited resources in every way, and those resources have nothing to do with you. You have no rights to them. I am to just accept defeat unfairly. Yes, absolutely. And be okay with everything. You don't have to be okay with it, but that's your choice. I am saddened how the justice system is so unjust and able to help people as myself who were once advocates for, I voted in jail. Nobody wanted you to do that. And raised to believe in the safety, indivisibility, and goodness and truth of, and what honor is supposed to be and where can always be found. Okay, have you ever seen the news? You were not paying attention. You were too drunk. Okay, the justice system is what it is. I'm not saying it's good or bad, but things happen all the time. And this is civil court. Yes, it's still supposed to be just and hear both sides, but this is not a criminal matter. So it's not like there's supposed to be some kind of there's not the same kind of services as when you're accused of a crime and you have risk of your freedom on the line. This is just he owes me $500 kind of thing, or we can't get along anymore. We need to divide our property. That's not the same. Okay. Not that it's not still extremely important and difficult to go through. I'm not trying to minimize that. Okay. I am severely disappointed. What do I have to say? Hold on. At this point in my life, I am severely disappointed in yourself, because you should be. What do I have to say? Anything to say, different or show for? That sentence makes no sense. Where is my testimony? It really is just question mark. I've communicated with everyone, tried to explain everything to make my efforts known. I have no access to a computer to check my status in this or documents being filed, no access to make viable phone calls to worthwhile agencies asking for my assist. Wasn't this supposed to be a summary? When did she say that? Okay. I've communicated with everyone, tried to explain everything to make my efforts known. I have no access to a computer to check my status in this or documents being filed, no access to make viable phone calls to worthwhile agencies asking for any assistance due to unauthorized numbers per OCCD rules. I can't even contact former husband's attorney to ask my questions and voice my concerns directly, which he wouldn't be able to answer. I've written so many letters, I've lost count. Then stop. I've tried everything, still trying in every way. What else can I do, Judge Dean? Please allow the mediation. Please help me in however you can. Please don't just show me where to sign former husband's unfair, incorrect paperwork. Any act of kindness, no matter how small, is ever wasted. Aesop. You are really quoting Aesop to the judge. Thank you always for your time, review, and understanding. For future reference and correspondence, please make sure to use my address as follows at the Orange County Jail. And then please be fair and see my point of view and determination. I try desperately every day to come up with solutions for and in everything. The reason I am again contacting you directly, hoping and praying you are able to use your right, proper, and unprejudiced judgment and authority to help someone as myself finally have testimony to the struggle which I am and have been long overdue for. I patiently await. Again, I am grateful. Thank you. Sincerely, Sarah Boone. And this is just kind of like a blank back of that page. So that was just a big long run-on sentence that said nothing. I don't understand why she thought sending this would be of any help in any way. So they dispense with mediation. Like, that's okay. That doesn't mean you can't go to the hearing and say the same things and tell your side. He already put in the order for you to be in person, which you wanted. So let's look at some of these certificates. This is the certificate of service to Sarah Boone, pro se respondent at the Orange County Jail on the 26th day of July. And this document was the motion to dispense of mediation. So this was sent to her on July 26th. This is the certificate of service sent to Sarah Boone at the Orange County Jail, pro se respondent. And this document is the order filed 8/11/2022 to dispense of mediation. So she wrote that letter July 17th. The order was not granted until, it says it was filed on July 26th. And this is the order, and it was on the 11th day of August, 2022. So at the time she wrote that letter on the 17th, it wasn't even, there wasn't even an order yet. And this was filed 8/11 on the court docket. This is the certificate of service for Sarah K. Boone at the Orange County Jail on the 22nd day of August. And this is the order setting the hearing. Okay. This is the certificate of service mailed to Sarah Boone on 8/25/2022 of Brian's financial affidavit that we looked at. Then she dated this first letter July 17th, addressed it to the Martell family law firm, talking about she was in receipt of the letter requesting the date to be set for the mediation, but that she couldn't give a date because she didn't have a crystal ball. And then you dated this letter the exact same day that you wrote to the judge, the exact same day you sent the letter to Brian's attorney saying you couldn't provide dates. You dated this letter the exact same day in your own handwriting that your son, and then you're saying coincidentally, your son just happened to open this letter on the exact same day that you wrote a whole other letter and just got back from a surgery. So I'm guessing you wrote this the next day because you're saying it in the past. So I guess you're saying you got back from surgery, called your son, he opened the letter, and then you wrote this on the same day that you wrote the other letter saying you couldn't provide dates because of the cancer. And then it wasn't filed until 8/29. So all that's just kind of, that doesn't add up to me is all I'm saying. And this next letter is dated September 9th, 2022 and was filed September 13th, 2022. Judge Dean, forgive me in advance. I am inadvertently lagging in the progress and updates of my case and need your assistance to help please provide clarification and explanation for multiple legitimate concerns I have that are hindering my right to be included in my case fully, honestly, and correctly. This past Friday, September 9th, 2022, that's the date you dated this letter. So how is it this past Friday if you're writing it today? I received a copy of the order for the case management conference for September 19th, 2022 at 3:30. The order was done and ordered on Monday, August 22nd, 2022. The copy of the order was postmarked Wednesday, September 7th, 2022. Why was I not mailed this the same day it was signed? Why were only former husband and his attorney in receipt? Why was I finally mailed a copy 2 weeks after completion? Would I have received last month? I could have had ample time to prepare and make arrangements to respond sooner. How is this acceptable? Your Honor, why am I not being included on and in everything the same time everyone else is? Oh, because you're in jail. I am either not at all mailed pertinent information and updates, it's sent to the wrong person, or I'm receiving last minute being made to scramble with the ongoing fear and threat of not being included, and is not by choice either. Do you all not understand, remember, or care that I am the other party, the respondent in this case? Well, that's why they mailed it to you, and you received it. The way I am being treated by all other parties is wrong, unjust, and seems unlawful, giving the appearance I don't care due to lack of responses and the extended length of time I take when I do from not receiving my needed documents to respond accordingly. So you're saying the judge is also wrong because you're saying all other parties are treating you wrong. So you wrote the judge to tell him he's wrong. Now I have only 5 days from receiving my copy on my end, which includes the time it takes for you to even receive this letter to prayerfully grant permission to me so I can be included at this case management conference, in my case next Monday. I do not have a legal representative or steward to also be included at this conference on my behalf, making my efforts and attempts more desperate and my want more ferocious. So you only have 5 days, and instead of writing your motion or answer or response, you immediately wrote this letter. Judge Dean, please understand, please see my determination and the never-ending hurdles continuously being pushed in front of me or thrown. Judge Dean, please understand, please see my determination and the never-ending hurdles continuously being pushed in front of me or thrown where I keep having to learn how to jump higher and higher and higher. Just know with my heartfelt will, my honorable cause and unbridled love for my son and my rights to be his mother, to be able to make competent, important, and valued decisions in his life, I'm going to learn how to fly over the hurdles in this case, my other case, and in my battle with cancer and any other health issue I'm dealing with. Fly, period. I'm not going to jump anymore. It is my right to be heard, seen, and respected. Well, Orange County revoked your right to even make your own decisions over yourself. So it's questionable why you should be able to make decisions over a child. And your right to be his mother, like you have the title, but you lost the privilege of spending every day with him and making these decisions because of your actions. Okay, that wasn't the end of a sentence. I'm sorry. It is my right to be heard, seen, and respected as the person and mother I am. It is not right in any way for me to be ignored, bypassed, and automatically overruled because I am poor with no family or support system. I am not mute. I am not mentally retarded or impaired. I am a loving, determined mother, friend, teacher, supporter. I am also an ex-wife. That ex-husband needs to conclude will always be in our son's life and his, and come to an acceptance of the situation, which nonetheless is temporary. Here, there, whenever, or wherever. Now, then, future. Former husband is going to have to respectfully deal with me one way or another. We have a child together. The sooner he comes to terms with all of this as I have, the sooner the beginning of his hard sought after quote unquote relief can start. He and whomever else also need to remember crystal balls are a novelty. Somebody's got some balls. I am doing everything in every way to stay afloat and still be a part of everything involving my son's life and mine. In the meantime, I have been providing quote unquote relief to former husband in numerous ways on a daily basis. Nothing was as difficult or tumultuous until he decided to devise his scheming, manipulative plans and agreements. No one would know this because no one is giving me a chance to be a part of anything. Although the playing field is completely uneven and the odds are stacked so high against me, I can't see the top and I have nothing. I'm going to fly. With that being said, and unfortunately at the last minute, now that you have received and read this, with only a couple of days remaining before the conference, I want and am entitled to be in attendance however necessary, so I am rightfully updated, present, and most importantly included for preparation of the upcoming hurdles futuristically. What needs to be done so I can be there Monday, September 19th, 2022 at 3:30 p.m. Courtroom 9B, Orange County Courthouse, Orlando, Florida, for the 30-minute allotted time given. transport order, video setup, telephonic appearance must be court ordered per the instructions on the copy of the order setting the hearing. How? It is not right if I am unable to attend this due to last minute attempted arrangements being made for me to do so. Would I have received the information when everyone else did 2 weeks ago? Timely plans could have been made and scheduled just as the order was on August 22nd, 2022. Today, September 9th, 2022. And finally, for whatever reason I am just now aware is scheduled. Please instruct me what I may need to do so I can cooperate and greatly increase my opportunity to be there. How can I validate and educate when no one listens, cares, or is in front of me? Yes, thank goodness no one is in front of you. Thank goodness. So what you need to do is pull out that crystal ball, dust it off, cast a spell, go back in time, and not take someone's life away if you want to be able to be included in everything in society. That's what you need to do. I thank you, as always, for your invaluable time, consideration, and much needed overdue assistance. Who else is there, Honorable Dean? It's like she's throwing shade here with the overdue assistance, like he's been negligent. I am also still waiting for your response for my most recent letter sent to you on August 17th, 2022. Regarding another order dispensing mediation. Does she mean July? Maybe she wrote the wrong month on it, because I thought it said July. Hold on. Hold, please. Okay, it definitely says July in her handwriting, but it was filed August 29th. It would make more sense if she wrote it on August 17th and it was filed on August 29th. So did she put the date wrong? Okay. Yeah, so she's saying she sent him a letter on August 17th. So maybe she wrote the date wrong on that letter. Regarding another order dispensing mediation, I never received and was only made aware was generated by my 11-year-old son reading to me due to being sent to his address. Please provide an update for that as well. Also on the order for the conference, I am graciously requesting to be included and a part of on page 2 of 2, where all parties were sent a true and correct copy. My address is incorrect. Please change so no other penalty, mistake, or reasons are made to be used against me in whatever way it seems everyone, especially former husband, is hoping will be my demise. Again, thank you, Judge Dean. I look forward to meeting you. Sincerely, Sarah Boone, and she has her correct and true address here. She needs to fill out an change of address form. I think she does end up doing that. But that's the end of that letter. Okay, so now we've gone over these 2 letters. And now let's take a look at the hearing, court minutes, the ruling, and the change of address form that Sarah completed and was then subsequently filed. These are the court minutes from the hearing held at 3:30 on September 19th, 2022. It says court opened at 3:33 p.m. on the 19th. And it says in no location. This case came on this day for case management conference. Honorable Michael Dean presiding. Brian and Sarah are listed and both were present. Hearing held in person. They have the attorney who appeared for Mr. Martell on behalf of the petitioner. The court ruling was the court will take no action on the notice for trial filed by Mr. Martell, Mr. Mendoza will provide an order to the court regarding any child support being vacated temporarily. This will be solely based on Mrs. Boone's incarceration. Mrs. Boone completed a change of address form in open court. Court recessed at 4 p.m., so it lasted exactly 27 minutes on this 19th day of September, subject to call. Filed in open court, 9/19/22. So that was a very brief case management conference that they had. It doesn't sound like they let Sarah talk very much if it was only 27 minutes. And so let's take a look at what else was filed. So this is the change of address, request for address change form that Sarah filed in open court, 9/19/22, her name. She authorizes the clerk of court to change my address to the following, basically the jail, Orange County Jail. She put her case numbers on there. And this was filed the next day, 9/20, on the court docket. And then Sarah wrote this follow-up letter. It's dated 9/23/22. It was filed 10/4/2022. Dear Judge Dean, I wanted to take a moment to thank you for allowing me to be in attendance during the case management meeting last Monday, 9/19. It has been such a long time since something good and real has happened to me since being incarcerated for ongoing 3 years almost. What she should have said was for being incarcerated for, instead of how long she's been in there, for what she did. She's incarcerated for her actions of taking someone out of the earth. I thank you profusely for helping me, listening to me, and having an open heart and mind to see me as a human being, a mother also. Your invaluable time, empathy, and understanding are beyond appreciated. Thank you for seeing me. I am so impressed, and my sincerest gratitude cannot be fully expressed for your kindness and goodness. I look forward to any future meetings there may be, and am confident my hard work, determination, and efforts will not return to me void or fall on deaf ears. A victory indeed in my battles in preparation for the war on the horizon. You should not speak to a judge about your case in the terms of battle and war. I will not creep away as I continue to be brave and fight on. Thank you for giving me hope more than you know. It was an honor to meet you, Your Honor. And then she lists a scripture here. As sorrowful, yet always rejoicing, as poor, yet making many rich, as having nothing and possessing all things. 2 Corinthians 6:10. P.S. Thank you for seeing that crystal balls don't work at all ever. Dust catchers, Sarah Boone. So this is the shortest letter she's probably written to the court. It's a one-pager. So that kind of concludes that little section. She does write another letter later on in October, and then the next one isn't until January. So let's take a look at that. Okay, so I think she felt like she had a victory because the court said they were going to take no action right now until her trial was concluded. And since she thought she was going to be victorious, as she described it in the trial, she felt like, okay, I'll get over that, get released, and then I'll go back and deal with this. That's what she kind of thought was going to happen. She filed her change of address, and we just looked at this letter. So she has one more letter in 2022, and then we'll be in 2023. So let's take a look at that one. So this letter she wrote 10/16. It was filed 10/18. Honorable Judge Michael Dean. Quote, we don't owe you anything and are waiting for you to be guilty so we can get out of here and away from you. I don't want to deal with you anymore. I'm going now. Click. Yelling at me so loud the phone is distorting. So loud former husband, his father, came in and told him to stop being mean to me before hanging up. So that's what her son must have said to her. Honorable Dean, This is what was told to me by my 11-year-old son when I asked about his best friend and how she was doing since he hadn't mentioned her in a while. He told me she started acting strange after he told her he was moving and wouldn't see her anymore. She's upset with him. The conversation continued with me asking why he's telling his friends this, as nothing is set in stone and will be discussed when the time comes. Oh, we're leaving, and it doesn't matter what you say. We have an attorney. Eventually, it turned into the aforementioned statement, and I was laughed at, disrespected, shut down, and hung up on by my son over asking about his friends. So, teenagers, kids, they get angry and they say things sometimes that are hurtful. And you have to be the adult and the mature one and kind of calmly deal with that situation. Kids can get emotional and yell, and he has every right to, since he's talking to his mother while incarcerated. And that's the whole reason he's having to move, because of you. You see, this is where I turn and ask, how is this okay, Your Honor? Because he's a child. This is exactly how former husband treats me and has unfortunately successfully passed this disgusting trait to our son. You mean expressing his emotions? There's nothing wrong with that. Nonetheless, how dare both of them disregard me the way they are, making me feel like I am nothing, no one, worthless, and a joke. I'm sick of being laughed at. You know who I bet was sick of being laughed at while he was struggling to breathe? George. I took it upon myself not to call back and waited until the next day. Oh, you took it upon yourself not to call back? That was so nice of you. Wow. And waited until the next day to talk about with former husband, calmly and rationally. I asked him why our son spoke to me the way he did, and where is he getting the idea you all are definitely leaving and moving? He's losing good friends over it. Well, people move. That is a fact of most people's lives, usually more than once. And you make new friends where you move. And also, you wrote in your own handwriting that the former husband told him to stop being mean when he said that. Okay. Well, that's the plan, and I figured you should start getting used to it. 50 miles can be overruled. It means nothing. Laughing. That's why I have an attorney and you don't. We're just waiting for you to be sentenced. The judge knows everything, and there's not much you can do or say about any of it. You'll see. We're leaving no matter what, regardless of the outcome. What's the point of me fighting for my life with my son when I'm treated the way I am by both of them? This is a form of mental and emotional abuse. Former husband encourages and enables it. I'm yelled at for everything. I'm afraid to call for fear I will be obliterated and brought to a new level of low, or tried to see how hard I can be made to cry, then laughed at. I'm damned if I do and damned if I don't. If I do continue in my fight, which I will and am, I'm disrespected and almost destroyed. If I don't, then I look like the uncaring, heartless, incompetent mother/person former husband is hell-bent on making me out to be. I just started speaking to my son from being screamed at with cruel lies and horrible mean things that I will not repeat over nothing. Probably truthful things that you did. And we know you won't repeat those things. Let's see. I just started. Okay. Cruel that I will not repeat over nothing. Sorry. I didn't call for 3 weeks because of the shock and pure hurt I am still in for what was said. And I'm sure those were a glorious 3 weeks for them. I am made to feel like a chore, burden, a pest. Then read the room and leave them alone. If talking to you is a chore, give him some space. I am not welcomed, like life is better without me. Well, Again, read the room. Everything is one-sided. My son never met my parents, grandparents, aunts, or uncles deceased, never knew my family. He only knows the Boones who viciously slander me, his mother, behind my back, have perpetually made me the dumb black sheep, and continuously plot my demise together. You handled that all by yourself. You sealed the deal on your own demise by filming what you filmed and doing what you did. And what can the judge possibly do about any of your family being gone? Nothing. They've poisoned my son and pitted him against me since day one when I was just 9 days into my incarceration. Okay. So since day one would be like when you got married, when you found out you were having a child. 9 days into incarceration, that's pretty far in. Okay. And being incarcerated for what you're incarcerated for would turn any in-laws against someone. That's a normal reaction. Former husband took it upon himself to make the egregious decision to tell him I would be gone and he wouldn't see me for 25 years or longer of his little life. My son cannot be my son and is tortured by the confusion in whether he can be close to me like we've always been or even be nice to me. That's because he's a small child dealing with big feelings that he shouldn't be having to deal with because of your actions. I feel, to be honest, our son is just an innocent pawn in former husband's scheme to seek his sad, bitter, unrelenting revenge against me. His halo is broken plastic and covered in fool's gold. Oh, you know all about fool's gold, Kentu Sukaroi. He is not the angel he appears to be. He is an insensitive, callous tyrant and fully endorsed by his family. No one listens to me. You know who you didn't listen to? George. And that's why you're here and no one cares what you have to say. Okay? So your husband isn't plotting revenge against you. You got yourself there and he is dealing with it the best he possibly can. I have made the active decision to not call for an undetermined length of time. What a breath of fresh air for everyone. So I can take a break from the beratement. I can only take the tears inflicted by former husband in doses. Right now, I've gotten my fill from both of them. If my son wants to speak to me, he can write or schedule a visit, which I doubt will happen from the lack of encouragement and inclusion of me to have a relationship with our son by former husband. Please understand, I can only take so much on top of everything else. I love my son. I need my son, just not this version, not right now. So kids go through different phases as they age and they become teenagers. They can be rebellious. They can come across as disrespectful. They're trying on different roles. They're experiencing different feelings. And this is part of being a parent, adjusting and adapting and being the parent your child needs at the time in all versions of themselves. What can I do? Nothing. What can you do, please? Nothing. This is not right. Every time I try to speak to former husband about anything, ends something, I don't know what that says, ends ugly and unsuccessful. He has taken it upon himself to self-diagnose my case from watching YouTube, his reliable source. We're getting all our stuff right out of your court docket that you complain about not being able to see. And of course, court TV telling me my trial is less than 3 weeks away, assumes I fired all of my attorneys. Remember, I am on number 6, but not by choice. Now you're telling the family court judge this, which is just going to make him go look into that. Because it's court documents. It's like very legitimate source. We're just reading them. and constantly tells me how wrong I'm doing everything. He keeps asking me why I keep delaying everything. He gives assumed case details about witnesses, occurrences, etc. over the phone, telling me about my case. You should be thanking him for that, because aren't you always complaining about being in the dark, not being able to see anything? Well, he can. He is assuming everything. He thinks he knows everything about my case. This is wrong. I'm being penalized even more for wrong, empty accusations and information. This only multiplies his anger and spitefulness towards me, thinking my strategy is to do everything I can to keep him here. Ludicrous. That is one adjective to describe your behavior. Ludicrous. This is why I felt the need, Judge Dean, to hesitantly include you in the ongoing struggles I'm having with former husband and his incompetency regarding my life and case. It's never ending and only gets worse. Now, your former husband, has freedom of speech. He has the right to an opinion that he can form on his own, and it doesn't have to come solely from your mouth, which is unreliable. There's nothing the judge can do about that. He might say, don't include your child in discussions of the case, but the child is going to find out about it regardless. I mean, your husband is having to do everything for your child and deal with all of the press coverage of what you did in the area where you did it, where it's even more hyped. But of course, we can't look at it through that lens. And you're showing the judge that you can't look at it through that lens, that you can only think about yourself. I would also like it to be known I have not gotten any of my orders for a hygiene kit, deodorant that works, toothpaste, and a washcloth, or for a measly coffee package that I began asking for in July. And after you approved on September 13th during our meeting, I thought it was the 19th, my ability to start receiving alimony again after former husband immensely diminished and tried to stop it's the middle of October. So he didn't say, she was at the meeting in person, and she still didn't take away what they ruled, because the minutes said they were not going to rule on it until after her criminal case. So I don't know why she thinks that the judge approved him sending her coffee and deodorant. There's always an excuse. The most recent and for the last 3 months is that his debit credit card won't work because it's a jail and people steal. He's had to use our son's allowance card just to finally get me a hot meal. I mentioned to you, which ended up coming on my birthday, 10/10, only because I told him about this letter I'm writing. I'm still waiting on the other orders so I can be alert and presentable when my attorney does finally show up, who still has not since the last time I spoke to you. Again, this judge can do nothing about your criminal attorney showing up. And you just admitted that you pestered your husband into sending you a hot meal to the point where he took your son's allowance to do so. And you were okay with that. Please know also, my bank account, which I've had for 30 years, has closed due to former husband's failure to pay alimony as instructed by our dissolution of marriage agreement, then also by you. No, he said he was not going to rule on it until after your criminal case. So he did not make a ruling or instruct him to continue. If he did say that's up to you, or however he verbally said it, that didn't mean it was an order. Your account did not close due to your former husband's failure to pay. It's because you are incarcerated and unable to manage your bank account. Okay. I cannot deposit any checks. One I've been waiting on for him to mail me since February and could use towards commissary when he wasn't giving anything. All of my subscriptions are not being renewed. Anything with auto pay cannot be approved. Who cares? That is not important. You need to focus on other things. Your subscriptions, you can't use any subscriptions. You're in jail. I can't even deposit. That would be the last thing I would be thinking about. Oh no, my Netflix is going to get and I'm not watching it. Why would I want to be paying for it? Good, let it get canceled. I can't even deposit the alimony former husband is supposed to be paying. I've had this account for 30 years. Yeah, you said that. He assumed his plan would work in not having to pay, so he withheld, causing this to happen. You know what else caused this to happen? Your actions. Because immediately after your actions of not letting someone out of a suitcase and filming it, you called former husband and he was like, nope, can't help you with that. You finally called 911 and acted like you tried doing CPR. The police made your home into a crime scene and took evidence, and you became arrested the next day for the charges you're there for. Second degree. So that is what caused all of this to happen. All of this is continuously falling dominoes from that one domino you pushed over when you said, F you, stupid, and you went upstairs and went to sleep. That was the domino that caused all of these to fall. You want to start in the middle of the domino chain and say, look, this caused this to fall. Yeah, each domino causes the next one to fall, but they all started with that first domino. If the first domino hadn't been knocked over, none of the others would have. I have no bank account, Your Honor. Well, join the club. Look around. There's plenty of people around you who don't have one either. Also, for all the difficulties he is supposedly encountering with his debit credit card, have you ever thought that he's trying to raise your child by himself? Have you ever thought that it could just be his own cash flow issue and he doesn't have extra money to send for you to have creature comforts in jail? He's trying to make sure your son is fed and a roof over his head, first and foremost. All of these could have been avoided would he had been paying and abiding by the rules. My bank account would be open still. He could have used my debit and credit card, and I would already have the necessities I'm needing. Former husband is his own troublemaker. Can we insert Sarah Boone? Here is her own troublemaker. He makes his life more difficult from all of his assumptions and defiant attitude. Even if I wasn't incarcerated, I'd be getting the same problems with him. He keeps tripping over his power trips and taking out on me. Where are my orders? How can I get my bank account reopened? He gets no relief from his own doing everything was okay before he tried implementing all his agreements and started a second job soothsaying. Wow. Just wow. The constant assaultive, degrading remarks, fear, infliction, and terrorizing threats must stop. It makes no difference how soft my approach is in trying to explain to former husband how unnecessary and harmful his actions and comments are, and being the example he is to our son, giving permission. What about your example? Giving permission he can do the same, especially to me, his mother, and also to other women futuristically. We knew that had to be thrown in here. Just stop, please. Former husband tries to taunt me every opportunity he can to get a reaction from me, knowing he's got the upper hand in almost everything and can either laugh at me or hang up or both. I would do that every time. I wouldn't even answer. You know why he has the upper hand? He didn't commit a crime, and you did. As said before, I am not helpless. I have God and your awareness of my situations, Judge Dean, to hopefully impose your authority in all manner above available to provide any permissible relief for everyone. So how's he going to provide relief for everyone if he gives you what you want? Because that's a burden. You are a burden. Something needs to be done sooner than later. Exactly. Considering my trial, they're trying. You won't let them. Considering my trial has an unknown date, I refuse to continue cooperating with former husband on any of his terms and the way they are being handled. Look at the bigger picture. All right, this right here is why they dispense with your mediation. What was the point? You refuse to continue to cooperate with your husband on any of his terms. You weren't going to do anything in mediation besides demand your way like a toddler having a tantrum. That's all that was going to happen. So that's why the judge ruled, you're putting the evidence right here. This is all he needs. This is all he needs. I refuse to cooperate. I refuse to cooperate right there. Okay. In conclusion, the most painful, horrific remark made to me by former husbands so far during my attempted call to talk about our son's upcoming birthday, with the conversation always turning into their exciting upcoming move, told me, when you're finally put away, this move will be the best thing to happen to us, him and son. We can't wait to get out of Orlando and away from you, laughing. Also, where we're moving is very close to the prison. It's going to be very easy and convenient for us. All of these are valid points. Why is that the worst thing he said? And he's probably talking about the upcoming move because they're trying to pack and get ready to move. That's what's going on in your kid's life. So just talk to him about what he wants to talk about. Thank you for your time and assistance. Most of all, your understanding. I waited as long as I could in everything to involve you, but I don't. Oh, you mean 2 weeks from the last letter? But I don't know what to do or how much more abuse I could endure. I felt you should be included on what's happening behind the scenes when former husband and his attorney aren't sitting in front of you in the courtroom, or you're reading one of their many scheming documents, plotting what he can do to me next. They're not scheming documents. Whoops, sorry. They're not scheming documents. They are legal documents. They are motions. They are requests. They are petitions. This is the legal process. They're doing everything by the book. They're not plotting what they can do to you next. They're following a legal process. That's it. You and God, thank you either way and always. Sincerely, Sarah Boone, Orlando, Florida. So that's the last letter she wrote. The next one will be starting the 2023 files to Judge Dean. So we've got a good couple pages of those. And then there's only like one thing in 2024, one or two things, and then we'll be in the 2025. So this has been part 3. I hope you have enjoyed these unhinged letters, and I will see you all in the comments. Thank you so much for watching.